Hello, hello, hello. Good morning, everyone. Give me a minute, I'll be right with you.
I'm over it. I told the woman across the couch, holding a notepad and a frown. I'm over it. I tell myself as my body goes into a panic, a slight prickle in my neck. I'm over it. I tell the woman across the couch, holding a notepad and a frown. I'm over it. I tell myself as my body goes into a panic, a slight prickle in my neck. I'm over it. I tell the man who wants me to give him my all, but he gets nothing but the scraps of a girl who once stood so tall. I'm over it. I tell my mother as she catches me in a haze, trying with everything I have to forget about that day. I'm over it. I tell my best friend as she begs me to go out, not planning to be anywhere to be found. I'm over it. I tell the hopeless victim who needs strength from a person who's felt the same tense stress. I'm over it. I tell the boy making the rape joke, hoping a weak woman is something he'll never know. I'm over it. I write to the man who made me feel dirty, who convinced me that I am not worthy. I'm over it. I tell the woman that is my reflection, as she sees her body as nothing but an imperfection. I'm over it. I tell the judge on trial when he makes his decision in complete denial. I'm over it. I tell the coach with every fiber of my being as he lets that boy back on the team. I'm over it. I tell the internet users who side with my abusers. I'm over it. I tell the world who says it's my fault. And somehow, along the lines, that's also what I thought. I'm over it. I snicker at the politician who thinks they know the role of a woman. I'm over it. I yell into the dark void that tells me I will never feel joy. I'm over it. I cry out loud in an awful dream, remembering the day I was told not to scream. I'm over it. I try to be just for an instant, because falling apart wouldn't make a difference. I'm over it. I utilize the innocence I used to know in her, because being taken advantage of is something I will never get over. I'm not over it. So let's all admit that the monsters are no longer under our bed, but now on top of it. It's time to take a stand, and we all need to come hand in hand for the ones who are just not over it.
Hello, 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 everyone. As I said before, good morning, Good evening for some. Good morning for me. Good morning for everyone in the East Coast. Good evening for everyone else. Good night for anyone else. How's everybody doing? Hello, everyone. Let's see who's in the building. We got Ty, Wifey, Alice. Hello, baby girl. Good to see you once again. Atmos. What's up? What's up? Tears. Hi, mama. Purple, purple. Hi, mommy. Oh, you're leaving us so soon, Alice. Don't leave us, Alice. Well, unless you have to go to work and good night, sweetheart. Have a good evening and sleep tight. Don't let the bed bugs bite. And have a good morning when you go to work in the morning. I know it's late and stuff. Hey, the truth. Yeah, so we got a new motion that came in, and it was a response. Did you guys get to hear the poetry that was did you guys get to hear the poetry I played just now? Well, I put the video link in the chat there, so if you guys didn't, you can go and watch it. And if you like the person's content, please subscribe to their channel. I found that to be a strong set of words, for women that go through abuse, sexual assault. So I hope everybody's doing good. And yes, we just got a motion in, and it's from the government. It came in a while ago. I thought I wasn't going to get it. I wound up grabbing it right before they sealed it up because now, I don't know, they sealed it up. So, thank God I got to grab it right as they were sealing it up. That's crazy. But it's in a response to the motion that I read the other day that they wanted to drop, the defense team wanted to drop the bribery charges as well as change the jury charge form as far as saying, because it just says guilty or not guilty. Now they want to add proven or not proven, and that goes to the herpes situation, right? All right, so let's see here what we got going on, y'all. Let me share my screen. Oh, okay, mama. All right, so just hang out and listen and relax. I'm going to try not to be loud because y'all know I'm always loud, screaming and shit. I don't want to be screaming today. So I'm going to share my screen with you guys. Okay. Okay. All right. So as we know, the response came in today. Okay. Which is September 19, 2021. And it's to the Honorable Judge Ann Donnelly. The case is United States versus Robert Sylvester Kelly. Docket number 19286. And it says, Dear Judge Donnelly, the government respectfully submits this letter One, in response to the defendant's September 18, 2021 letter motion seeking an amendment of the proposed jury instructions, which includes a request that Racketeering Act 1 be dismissed. And then it says ECF 219, and 2, seeking certain clarifications and additions to the proposed jury instructions for the reasons set forth below, with the exception of the defendant's motion as it pertains to Racketeering Act 9. And the motion should be denied. So the government's saying that, listen, Judge, this is my response to their motion that they put in yesterday, their letter of motion seeking amendment, okay, to change the question on the jury questionnaire and to drop the bribery act, the Racketeering Act 1, which falls under the bribery. So now they're like, no, please, Judge, the motion should be denied, Judge. We should deny this, Judge. We should deny this, Judge. Okay? And it says that the defendant's motion to dismiss Racketeering Act 1 and his request to charge regarding Racketeering Act 1. And it says that the court, meaning the judge, and it's telling the judge that she should reject it. The court should reject the defendant's assertion that Racketeering Act 1 be dismissed. As a preliminary matter, the defendant's request to dismiss Racketeering Act 1 is premature as the government has not yet rested its case in chief. Oh. Did y'all hear that? Did you hear that? The court should reject the defendant's assertion that Racketeering Act 1 be dismissed as a preliminary matter. The defendant's request to dismiss Racketeering Act 1 is premature. It's premature, guys. And why is it premature? Because the government has not yet rested its case in chief. So that's telling us that the government is not resting yet. The government has more to prove and more to show. So that tells me that tomorrow the government shall continue with their case. They're not done yet. That's what it sounds like to me. I don't know. That's what it sounds like to me. What do you think, guys? Yeah, get those likes up, guys. There's only 5 of you in there. There's only 5 of us here. So just get the likes up. I know it's like 12:30 a.m. Nobody wants to hear what I got to say. Everybody wants to go to sleep. It's Sunday. People got to go to work. But get those likes up, guys. And if you're going to watch the replay, please make sure you hit the like button, guys. Thank you. But for me, right, sounds like they got more bombs to drop. Exactly, Tears. Blade! Tears! If you're in the bushes, Blade, I love you. That's what it sounds like to me. So, then it says, moreover, the defendant erroneously, erroneously, I cannot pronounce that word, guys. Forgive me for chopping the shit up, okay? Hooked on phonics did not work for me in this sentence, okay? Erroneously, okay, moreover, the defendant claims that the defendant must have himself tendered the property at issue. So, moreover, the defendant, he claims that, erroneously claims that the defendant must have himself tendered the property at issue. Right. So, right, they're saying that, right, they were saying, like I was saying in the motion, that the defense is trying to say that because R. Kelly didn't actually make the transactions himself, it should be dismissed because therefore he didn't do the bribery. It was two other people and the employee that they bribed, right? So it says that the property at issue here is approximately $500 in cash to an employee at the Illinois Department of Public Aid, which is the IDPA, in order for the government to prove that the defendant committed the crime alleged in Racketeering Act 1. So, as set forth in the third superseding indictment, which is the indictment, because that's what they're going off now, the third superseding indictment, that's the indictment. That's the one to go by, which is the March of 2020 indictment. That's the indictment they're going by. It says the defendant is charged with committing bribery in violation of Illinois Criminal Code sections 533-1A and 5/5-1. Indictment at area 13, at paragraph 13, it says, pursuant to Illinois Criminal Code section 5/5-1, which is A, and it says that person is responsible for conduct, right? A person is responsible for conduct which is an element, right? Keyword, element of an offense if the conduct is either that of the person himself or that of another, and he is legally accountable for such conduct as provided in section 5.2 or both. So as set forth in pertinent part in section 5-2. See, so remember what I was saying, guys, that I was saying that even if it doesn't matter, because even if the bribery, he didn't physically do it himself and exchange hand in hand, he's still responsible for that because he planned it. He was part of the plan. He knew it. So now they're going to explain here that, again, in section A, okay, which is 5-2, okay, section 5-2, or both, right, as set forth in it, it says that person is legally accountable, okay? A person is legally accountable for the conduct of another when B, the statute defining the offense makes him or her so accountable, or C, either before or during the commission, keywords, of an offense, and with the intent to promote or facilitate that commission. He or she solicits, aids, abets, agrees, or attempts to aid that other person in the planning or commission of the offense. Okay? So, right here, it's telling you that it doesn't matter, okay? It could have been somebody else that did it, but he knew of it. He knew about the plans. He agreed. He solicited. You understand? So, allegedly, he did these things according to law. And then it says that Illinois Criminal Code Section 552, accordingly, under Illinois Criminal Code Sections 533, 1A, and 5-51, the defendant does not need to have directly furnished the currency to the IDPA employee himself in order for the jury to find Racketeering Act 1 proven. Indeed, under the law, the defendant not need even have been present when the bribe was furnished to the IDPA employee. So then it goes to show, see Illinois Pattern Jury Instructions 503 and 506, in where it says that actual physical presence at the commission of a crime is not a requirement for legal responsibility. Actual physical presence at the commission of a crime is not a requirement for legal responsibility. Nor does the defendant have to provide the currency himself to an intermediary in order to be found to have committed Racketeering Act 1. As discussed above, under Section 551, the defendant is legally accountable for the conduct of another, where he solicits, aids, abets, agrees, or attempts to aid the other person in planning or commission of the offense. And then it says the code again. This says, given that the defendant is charged in the indictment with committing the bribery alleged in Racketeering Act 1 in violation of Illinois Criminal Code Sections 533, 1 and 515, 5/51. The government respectfully submits the proposed amended jury charge. Attached hereto as Exhibit A, with respect to Racketeering Act 1, to ensure clarity and reflect the various manners in which the jury may find Racketeering Act proven under the law as charged. So, in other words, they're saying, listen, we're doing this the way it's supposed to be. We are charging him the way he's supposed to be charged. So, no, Please, Judge, don't let them dismiss this. Thank you. That's it. That's all. Wings! So then it says that including through the use of an intermediary as well as through the defendant's own legal accountability for the conduct of another under Illinois law, the government respectfully requests that the court adopt the government's amended proposed jury instruction for Racketeering Act 1 set forth in Exhibit A. Then it says, finally, with respect to Racketeering Act 1, there is currently ample evidence in the record reflecting the defendant's participation in the bribery scheme, including, but not limited to, testimony regarding the defendant being present in the hotel room where Demetrius Smith suggested he could bribe an employee at the IDPA. The defendant accompanying Smith and Aaliyah Houghton to the local office where the IDPA employee was bribed in exchange for a fraudulent identification card for Aaliyah Houghton. Now, the defendant's motive for obtaining said identification and the defendant's clear control and micromanaging of the conduct of his employees and other members of his inner circle. The defendant's motion to dismiss should therefore be denied, and the government respectfully requests that the court include the attached amended instructions as part of its charge to the jury. So we know we're talking about the jury charges, which was the instructions on how to give your verdict, with the law and what you should look at and not look at, right? So it says the defendant's request to charge regarding Racketeering Act 8 and California Health and Safety Code 12290. It says that the defendant asserts that the jury instruction for Racketeering Act 8 are wrong with respect to their reference to California Health and Safety Code 12290. Now, the defendant is mistaken and relies on the wrong version of the 12290 to assert that an amendment is necessary. So she's like, listen, he put in the wrong thing and he's trying to act like he's right when he's really wrong. And he wants me to do this correction and he wants you to do this because he's trying to be slick. Then it says, the defendant quotes the version of the statute that did not go into effect until January 1st of 2018, and which is currently operative. Then it says that the indictment and the correlative jury instructions, however, makes clear that the version of 12290 at issue is the version that was effective from 1998 through May 26th of 2016, which covers the period in which the conduct charged in Racketeering Act 8 is alleged to have occurred. Example, on or about and between April 28, 2015, and May 1st, 2015. Now, with respect to Racketeering Act 8A, the indictment reads as follows. Okay. Give me a second. Let me get some water, guys. I forgot to grab my water. Hey, West Coast Beta. Hello. Wings. I love you. Tarsha. What's up, mama? All right. So now it says that with respect to Racketeering Act 8A, the indictment reads as follows. It says on or about and between April 28, 2015 and May 1st, 2015, both dates being approximate and inclusive within the Central District of California, the Northern District of California, and elsewhere, the defendant Robert Sylvester Kelly, together with others, did knowingly and intentionally transport an individual, to wit, Jane Doe number 5, an individual whose identity is known to the grand jury, in interstate commerce with intent that such individual engage in sexual activity for which a person can be charged with a criminal offense, to wit, violations of California Health and Safety Code 12290, effective 1998. Willful exposure of a communicable disease. So in that Kelly engaged in unprotected sexual intercourse with Jane Doe number 5 without first informing Jane Doe number 5 that he had contracted herpes and obtaining her consent to sexual intercourse in these circumstances. In violation of Title 18 United States Code, Sections 2421A and 2. Now, in the indictment of paragraph 23, emphasis is added there. And it says that with respect to Racketeering Act 8B, the indictment reads as follows. On or about and between April 28, 2015 and May 1st, 2015, both dates being approximate and inclusive within the Central District of California, the Northern District of California, and elsewhere, the defendant Robert Sylvester Kelly, together with others, did knowingly and intentionally persuade, induce, entice, and coerce an individual, to wit, Jane Doe number 5, to travel in interstate commerce to engage in sexual activity, for which a person can be charged with a criminal offense, to wit, violations of California Health and Safety Code 12290. Effective 1998, willful exposure of a communicable disease. In that, Kelly engaged in unprotected sexual intercourse with Jane Doe 5 without first informing Jane Doe 5 that he had contracted herpes and obtaining her consent to sexual intercourse in these circumstances, in violation of Title 18 United States Code, Section 2422, A and 2. Now, in the indictment on paragraph 24, it says that in 2015, the operative version of 12290 titled Willful Exposure of a Communicable Disease provided in its entirety as follows. Except as provided in section 120-291, or in the case of the removal of an afflicted person in a manner the least dangerous to the public health. Any person afflicted with any contagious, infectious, or communicable disease who willfully exposes himself or herself to another person, and any person who willfully exposes another person afflicted with the disease to someone else, is guilty of a misdemeanor. Wow. Just a misdemeanor, huh? That's crazy. Oh, my glasses, my eyes. Oh, they're bugging out. I can't wait to get my new glasses now. So, wow, misdemeanor. Go figure that. That's crazy. Now, California Health and Safety Code 12290, effective 1988, the text of the statute that the defendant cites, including the language regarding specific intent to transmit an infections or communicable disease. It says docket number 219 at 5-6 did not come into effect until after the conduct charged in Racketeering Act, charged in Racketeering Act 8. As a result, the government's proposed jury charge regarding 12290 properly quotes the relevant portion of 12290 that was in effect at the time of the charged conduct and properly sets forth the elements of the charged conduct as set forth in the government's proposed jury charge at the time of the charged conduct. 12290 required that the defendant act willfully, not with specific intent to transmit an infectious or communicable disease, as the defendant's proposed instructions would require. Docket number 219 at 6, as set forth in the government's proposed jury charge, CECF docket number, and it has a whole bunch of docket numbers, as set forth in the government's proposed jury charge. Then it says another docket number 117, that's 60 and 14. Both at the time of the charged conduct and now, California law provided that the word willfully, when applied to the intent with which an act is done or implemented, or omitted, implies simply a purpose or willingness to commit the act or make the omission referred to. It does not require any intent to violate law or to injure another or to acquire any. So, he intentionally and willfully did it, according to the government. uh, Oh, sorry, guys. Uh, then it says that the 1998 amendment to the statute added the reference to a new separate provision in California's Health and Safety Code, namely Section 12291. Specifically, Section 12291 made it a felony and provided harsher penalties for individuals who exposed others to the HIV virus by engaging in unprotected sexual activity without first disclosing their HIV positive status and acted with specific intent to infect the other person with HIV. This version of 12291 was in effect at the time of the conduct charge in Racketeering Acts 8A and 8B. Okay. All right, so wait, the last words, wait, because I hate that. Let me go back. All right, so it says that, or to acquire any advantage. And then it cites the laws. And then it says that willfully implies no evil intent. So the defendant's proposed change to the jury charge with respect to the intent required for Racketeering Acts 8 should therefore be rejected. And the third, the defendant's request to charge regarding Racketeering Act 9. With respect to Racketeering Act 9, the defendant requests the inclusion of an instruction regarding mistake of fact with respect to the minor's age. Docket number 219 at 7. The government agrees that the substance of the defendant's proposed instruction indicating that a reasonable belief that the minor was 18 years of age is a defense and should be included in the charge. The government respectfully requests a slightly differently worded instruction regarding this matter. However, as described below. Hey, Darcy, what's up, mama? Then it says that as an initial matter, however, the government respectfully alerts the court to a typographical error in the language in the indictment with respect to Racketeering Act 9, which is repeated in each of its subparts, which the government respectfully submits that the court should correct. So specifically in Racketeering Acts 9A, 9B, 9C, and 9D, there is a typographical error in the final to-wit clause for these acts. Those paragraphs currently state in relevant part that the defendant either transported or coerced, enticed an individual who had not yet married the age of 18. Jane Doe number 5, to travel in interstate commerce with intent that such individual engage in sexual activity for which a person can be charged with the criminal offense. Two-wit violations of California penal law, sections, unlawful sexual intercourse with the person under 18 years old. Bleh. I'm getting sluggish, guys. Bueno, right? Right, Darcy? Bueno. Bueno means good, for those who don't know. Okay. This is like a whole bunch of Lord. Okay. My eyes, and I only got like 3 more pages left, but this is just, okay. Let's see. No. The Racketeering Act 5, where they say, finally, the government respectfully requests that the court add the following language to the jury instruction for Racketeering Act 5. After the sentence, evidence of emission of semen is not required to prove sexual penetration. It is a defense to the charge of aggravated criminal sexual abuse that the defendant reasonably believed Jane Doe number 4 to be 17 years of age or older at the time the acts of sexual penetration were committed. Lord of mercy. Yeah, I'm getting sluggish, guys. I'm ready to, the words are just going. They're going. So you know what I'm going to do? I'm going to let the reader read the rest of this out for me. How about that? How about that, guys? Just so I don't start slurring my words and falling asleep on y'all. Word. Let me see if I can put on my little read out loud.
Advantage. Cal, Penal Law 7, 1, effective until 2016. See also People v. Valdez, 27 calories. Fourth 778, 787 to 788, 2002, cf. People v. Atkins, 25 calories. Fourth 76, 85, 2000, willfully implies no evil intent. The defendant's proposed changes to the jury charge with respect to the intent required for Racketeering Acts 8 should, therefore, be rejected. 3. The defendant's request to charge regarding Racketeering Act 9. With respect to Racketeering Act 9, the defendant requests the inclusion of an instruction regarding mistake of fact with respect to the minor's age. ECF Docket No. 219 at 7. The government agrees that the substance of the defendant's proposed instruction indicating that a reasonable belief that the minor was 18 years of age is a defense and should be included in the jury charge. The government respectfully requests a slightly differently worded instruction regarding this matter, however, as described below. As an initial matter, however, the government respectfully alerts the court to a typographical error in the language in the indictment with respect to Racketeering Act 9, which is repeated in each of its subparts, which the government respectfully submits that the court should correct. Specifically, in Racketeering Acts 9A, 9B, 9C, and 9D, there is a typographical error in the final to wit clause for these acts. Those paragraphs currently state, in relevant part, that the defendant either transported or coerced/enticed an individual who had not yet attained the age of 18, Jane Doe number 5, to travel in interstate commerce with intent that such individual engage in sexual activity for which a person can be charged with a criminal offense, to wit, violations of California Penal Law sections 261.5A and 261.5B, unlawful sexual intercourse with a person under 18 years old, in that Kelly engaged in sexual intercourse with Jane Doe number 5, who was under 18 years old, while he was more than 3 years older than Jane Doe number 5, in violation of federal law. Indictment paragraphs 26 through 29, emphasis added. The typographical error is in the citation to section 261.5b, which is the rest of the language in the relevant paragraphs makes clear, is in error, and should be corrected to cite to section 261.5c. The relevant portions of section 261.5 of the California Penal Law are set forth below. A. Unlawful sexual intercourse is an act of sexual intercourse accomplished with a person who is not the spouse of the perpetrator, if the person is a minor. For the purposes of this section, a minor is a person under the age of 18 years, and an adult is a person who is at least 18 years of age. B. Any person who engages in an act of unlawful sexual intercourse with a minor who is not more than 3 years older or 3 years younger than the perpetrator is guilty of a misdemeanor. C. Any person who engages in an act of unlawful sexual intercourse with a minor who is more than 3 years younger than the perpetrator is guilty of either a misdemeanor or a felony and shall be punished by imprisonment in a county jail. 6. Not exceeding 1 year, or by imprisonment pursuant to subdivision H of Section 1170. California Penal Law Section 261.5 A-C. The indictment correctly cites to Section 261.5 A, which defines unlawful sexual intercourse with a minor. The indictment erroneously cites to Section 261.5 B, which is the subsection that applies if the minor is within 3 years of age of the perpetrator. This is clearly a typographical error, given that the indictment immediately thereafter provides notice of the specific conduct at issue that is violative of Section 261.5, stating, in that Kelly engaged in sexual intercourse with Jane Doe No. 5, who was under 18 years old, while he was more than 3 years older than Jane Doe No. 5, in violation of federal law. Indictment paragraphs 26 through 29, emphasis added. Section 261.5 C is the provision that applies in such circumstances. See Cal. Penal Law Section 261.5 C. Any person who engages in an act of unlawful sexual intercourse with a minor who is more than 3 years younger than the perpetrator is guilty of a crime. The government respectfully submits that the court should correct this typographical error in the indictment and amend the jury charge accordingly. See United States v. Dinsa, 243 F.3d 635, 667, 2 DCIR 2001. The requirement that the grand jury amend the indictment is not absolute. The district court or the prosecutor may make ministerial change to the indictment, such as to correct a misnomer or typographical errors. Alteration in original. United States v. Miller, 116 F.3d 661, 669, 2 DCIR 1997. Prosecutor may move for a minor correction of an indictment because the correction of merely technical errors, such as typographical or clerical mistakes, is permissible where it does not alter the essential substance of the charging terms. United States v. Dames, 386 F.2d 523, SDNY 2005, holding that amendment by court of citation in indictment appropriate where indictment mistakenly cited wrong subsection of 18 U.S.C. Section 924 and indictment provided notice in its language as to correct subsection, Federal R. CRIMP 7, C2, citation error. Unless the defendant was misled and thereby prejudiced, neither an error in a citation nor a citation's omission is a ground to dismiss the indictment, or information, or to reverse a conviction. Given the clear language in the indictment, the defendant had ample notice of the violative conduct at issue, and the requested typographical correction does not alter the essential substance of the charging terms in any way. With this typographical error corrected, the government respectfully submits that the following jury charge with respect to Racketeering Act 9 should be used, which incorporates the substance of the instruction requested by defense counsel. 2. The indictment provides that the defendant violated California law by engaging in sexual intercourse with Jane Doe No. 5, who was under 18 years old, while he was more than 3 years older than Jane Doe No. 5. California law provides that a New York person who engages in an act of unlawful sexual intercourse. 2. The government also respectfully requests that the court delete the following language from pages 65 and 68 of the government's proposed jury charge with respect to Racketeering Acts 9C and 9D. The government need not prove that the defendant knew the minor was less than 18 years old. 7. With a minor who is more than 3 years younger than the perpetrator is guilty of a crime. Unlawful sexual intercourse is an act of sexual intercourse accomplished with a person who is not the spouse of the perpetrator, if the person is a minor. For the purposes of this section, A minor is a person under the age of 18 years, and an adult is a person who is at least 18 years of age. To prove a violation of this provision of California law, the government must prove that 1. The defendant had sexual intercourse with Jane Doe number 5. 2. The defendant and Jane Doe number 5 were not married to each other at the time of the intercourse, and 3. At the time of the intercourse, Jane Doe number 5 was under the age of 18 and more than 3 years younger than the defendant. Sexual intercourse means any penetration, no matter how slight, of the vagina or genitalia by the penis. Ejaculation is not required. It is not a defense that Jane Doe number 5 may have consented to the intercourse. Defense, good faith belief 18, or over the defendant is not guilty of this violation of California law if he reasonably and actually believed that Jane Doe number 5 was age 18 or older at the time of the charged intercourse. The government must prove beyond a reasonable doubt that the defendant did not reasonably and actually believe that Jane Doe number 5 was at least 18 years old. Point 3. 4. Racketeering Act 3. The government also submits amended and supplemental language to its proposed jury charge regarding Racketeering Act 3. Similar to Racketeering Act 1, Racketeering Act 3 charges that the defendant committed the alleged offense in violation of Illinois Criminal Code 5/10-1 and 5/5-1. Accordingly, the government's proposed amended jury instruction, attached as Exhibit C, reflects accountability liability as charged in the indictment under Illinois law. The government respectfully requests that the court adopt the government's amended proposed jury instruction for Racketeering Act 3 set forth in Exhibit C. 3C Calcrim number 1071, Unlawful Sexual Intercourse, Minor more than 3 years younger, Penn. Code, Section 261.5. A and C, available at www.justia.com/criminal/docs/calcrim/1000/1071, attached hereto as Exhibit B. 8. V. Racketeering Act 5. Finally, the government respectfully requests that the court add the following language to the jury instruction for Racketeering Act 5. After the sentence, evidence of emission of semen is not required to prove sexual penetration. It is a defense to the charge of aggravated criminal sexual abuse that the defendant reasonably believed Jane Doe number 4 to be 17 years of age or older at the time the acts of sexual penetration were committed. 4. Respectfully submitted. Jacqueline M. Cassellis, Acting United States Attorney. By /S/ Elizabeth Geddes Nadia Shiata Maria Cruz Melendez, Assistant U.S. Attorney 718254.
So there's the reasons why they should be denied. They made a mistake on one part and they made a mistake on the other part, and they need to correct themselves. Yeah. So I found the video from our girl, Miss Coach Belize. All right. She's Belize Spivey on YouTube. And she talks about, remember that she was talking about the herpes situation the last time for us? This is her video there. And in this video, she's talking about R. Kelly. So let's check out and see what Miss Coach Belize has to say about R. Kelly and the whole herpes situation. Let's see. Now, the title of her video is called R. Kelly is Getting Sued for Herpes. And then she says, How 101. So let's check this out. I'm going to share my screen. All right, guys, you know I'm going to go on mute, okay?
All right, guys, it's going down. It's going down. Y'all know my energy going to be high now. If you thought my energy was high the other day, it's going down today. Okay, so I'm going to let you guys know. Invite your friends. Share this video because it's going down. I'm being honest. It's going down. If you want to know how we feel on this side of the fence with herpes today, I want y'all to understand this video is from an individual who has genital herpes. This is from an individual who also have type 1 and type 2, which I have a cold sores too. Hey, y'all. All right. So I'm telling you now, today's video is from somebody who has type 1 and type 2 herpes. This is not from a blogger. This is not from somebody who's just saying their opinions. This is not from an individual who's speaking through nobody else's experience. Today is from somebody who's on this side of the fence. Okay? So I want to tell my personal, it's not going to all be personal. I'm going to kind of play like devil's advocate in a sense with everybody. Hey, everyone, I'm going to play devil's advocate. So don't think I'm picking sides. Don't think that I'm agreeing with anything. Don't think any of that. I'm telling y'all, I need somebody to tag Shade Room for me. Tag me in these blogs like today because this video need to go viral. Because what we not going to do today is have other people speak on what they don't know nothing about. Okay? I'm going to speak for somebody who understands. I'm also going to speak from legal. I did some research as well for y'all to understand what's about to go down. Okay, with R. Kelly. Okay, let's get into this, guys. If y'all have any questions, concerns, comments, put it in here. I may not read everything, but best believe, put it below. All right. So let y'all know I am Belize Spivey. I am known as the SC Life Coach. I'm the first Black woman to come out and talk about herpes on a big platform. I have YouTube. I'm huge on YouTube, went viral on YouTube, all this other stuff. But I came out because I did not have anybody to talk to, anybody to go to, anything to do. I didn't know what to do. And I didn't see Black women talk about it, okay? Or Black people talk about it. And clearly I was like, well, we're being affected. We need to talk. So I decided to do this. So today, that's who I am. But this is what we're going to talk about. All right, y'all. Whew. Okay, I ain't gonna see no poor old R. Kelly because at the end of the day, what R. Kelly did was wrong. Period. He was messing with underage girls. The story is all over the place. I truly think everybody involved should be put, like, literally needs to go to jail because I really think that was just pure sex trafficking, parents included. Okay, that's just my personal opinion. I don't think it's right. It's happening all the time. I'm seeing a lot of people come out talking about, grown men or grown women having sex with children. Not right, period. Okay? Not right, period. I'm not agreeing with any of this, but this is about herpes. Okay, so as you can see on the blogs, if you have been on Shade Room, if you have been on I can't remember the other one, but if you have been anybody who talking about blogs, R. Kelly is trending. They're saying right now that his lawyers are trying to fight about herpes. Okay, he has 9 counts on herpes right now, 9 counts, and 2 was intentional. So they didn't say quite sure if those 9 counts say it was intentional or they found out after, but they say 2 counts are based off of he knew. Okay, his lawyers are stating that herpes is not considered an STI. Okay, let me stop right there. Okay, I agree and I also disagree. Okay, playing devil's advocate, y'all. I disagree in the sense that herpes is not always considered an STI. Okay, this is why people get cold sores, children get cold sores. Everybody's not having sex. Let's be honest. Some people are like literally not having sex. But if you kiss somebody and they have herpes, it can happen. You can get herpes on your fingers. Herpes is skin to skin. Period. I'm gonna say this: skin to skin. If you ever heard of rustlers, mats, herpes, literally they're on top of each other. Things like that. herpes can be passed, okay? So that's not sexual. Kissing is not always a sexual thing. It could just be affection. That could be a greeting with you and your family, things of that nature. Son, stop jumping down them steps. Yeah, boy, go that way. I'm sorry, y'all. I'm a mama and they're never gonna stop. Okay. So, with that being said, it's not always that way. Most people get cold sores and fever blisters from parents or, simply kids or drinking after people who have outbreaks and things like that, or using items after somebody who have an outbreak. Okay, that's things like that. So that's not always sexual. So I can see how they're trying to pull that herpes is not an STI thing. But I'm not quite sure. I haven't seen, and somebody please tag it. But I did not see, the blog that I looked at, it did not state if he had genital or oral. Okay, they just said herpes. And I want to say this, guys, literally, genital or herpes are locations. They're not, if y'all get caught up into the type 1, type 2, that was really to identify location. That had nothing to do with really a type. So don't get caught up on that. Herpes is herpes, okay? So I see why they're saying it's not a STI, all right? But, let me give you the but, okay? But when you perform sexual acts, that's when it becomes an STI, which most of us know his story. He wasn't into having sex. He was into watching, and he was also into getting oral performed on him. Okay, he was a watcher and a receiver. He really wasn't he wasn't really a doer. Okay, so just to let you know, that means possibly, as we know, he was probably genital anyway, and he's getting oral sex performed on him. So like I said, he got 9 counts. That is right now 9 counts, 2 very much known, but his lawyers are saying that STI is not considered STI. That's not true for him, and let me explain why. As we know, R. Kelly is in New York right now. He's locked up in New York. Let me tell you the laws in New York. Okay, let me read here. In New York, it is a misdemeanor for a person who knows he or she is infected with an STI. And I'm going to say STI, STIs, we don't really use that anymore, to have sexual intercourse with another person. People who know that they're infected with an STI, they can cause, that's not the case. They can say you can cause death or commit a sexual crime. Let's stop here. People who know they have an infection with STI that can cause death or commit a sexual crime. As we know, R. Kelly committed a sexual crime. He has sex with minors. So this is where he's going to have a problem. Because at the end of the day, right now in New York, STIs, and this is where he's saying it's not included. They will say here, New York laws does not provide a list of sexual transmitted diseases. Okay, I understand. Let's go back to the panel. If we go back to the panel, herpes is not included in the standard panel. So I can see how they want to try to get away with that, because at the end of the day, herpes is not included on the panel. What's included on the panel? HIV, gonorrhea, syphilis, chlamydia, trichomoniasis. Those are the things that's included. Herpes is not. So if you go based off what CDC is saying, what standard, then herpes is not a standard STI. So they're trying to prove saying that herpes is not an STI if it's not included in the panel. I see what they mean. This is why the laws has to be changed. Thank you, R. Kelly situation. This is why the laws need to be changed. Because at the end of the day, you're not saying it's included. But this is the problem. He committed a sexual crime. I'm not saying, and let me say this. I'm not aware if he knew prior to having sex with these young ladies. As we know, most of these young ladies now are not minors, they are adults. So I don't know. I'm going to say this. I don't know when he found out his status. Not clearly, he got to speak that out, or somebody got to tell when he found that out. If you know anything about herpes, by watching me, you know that you can have herpes for so long and have no clue. Many people don't even realize what herpes look like. Many people don't even know that herpes is not on the panel. And when you don't know things like that, then most people are having sex with people thinking, I'm good. I'm being honest. I'm good. So I'm not going to say that he knew all those counts. Okay. This is just speaking. I'm not I'm not protecting him. I'm just saying some of those counts. What if he did not know his status? Okay. What if he just ended up finding his status later? Oh, devil's advocate. What if his doctor told him that he do not have to disclose? Police, nobody doing that? Yes, they are. Okay, yes, they are. CDC is not included in the testing. So how would a no person really know that they have it? Oh, police, how do you get tested? You get tested with getting a blood test, or you're getting a culture. Most doctors do not want to test you based off blood tests because the tests are not that accurate. That's a problem. That's the reason why it's not included in the standard. Because if I don't have any symptoms, they want to say that we don't want to deal with it. So basically, if R. Kelly ended up getting tested and it was confirmed, it could have been through a blood test, or it could have been through him having an outbreak at that time. Most doctors want to see the outbreak to do a culture. A culture is a PCR. I'm going to be a little technical. A PCR when they do a culture of it. We know what cultures are. They typically do, if anything, if anybody you think you got a cancer or something, they will take it, and that's a culture. Okay? So they'll take a culture and they'll go on a microscope and look. So there's no way to really know what way he found, but that is how most doctors do it. And we'll be honest, I challenge y'all to call y'all OBGYNs and your doctors today and ask them if herpes included in standard testing. And I want you to also tell me, DM me and tell me what they told you.
You see that, guys? A herpes test is not a standard test. When you go to the doctors, they do not give you those tests unless you have an outbreak. That's the only way they will do that. And my internet's being funny. Oh, not now. It's unstable. Okay. All right, let's go back to the video.
All those counts, okay? This is just speaking. I'm not protecting them. I'm just saying some of those counts. What if he did not know his status? Okay. What if he just ended up finding his status later? Oh, devil's advocate. What if his doctor told him that he do not have to disclose? Police, nobody doing that? Yes, they are. Okay. Yes, they are. CDC is not included in the testing. So how would a no person really know that they have it? Oh, police, how do you get tested? You get tested with getting a blood test, or you're getting a culture. Most doctors do not want to test you based off blood tests because the tests are not that accurate. That's a problem. That's the reason why it's not included in the standard. Because if I don't have any symptoms, they want to say that we don't want to deal with it. So basically, if R. Kelly ended up getting tested and it was confirmed, it could have been through a blood test, or it could have been through him having an outbreak at that time. Most doctors want to see the outbreak to do a culture. A culture is a PCR. I'm going to be a little technical. A PCR when they do a culture of it. We know what cultures are. They typically do, if anything, if anybody you think you got a cancer or something, they will take it, and that's a culture. Okay? So they'll take a culture and they'll go on a microscope and look. So there's no way to really know what way he found, but that is how most doctors do it. And we'll be honest, I challenge y'all to call y'all OBGYNs and your doctors today and ask them if herpes included in standard testing. And I want you to also tell me, DM me and tell me what they told you. Most of them will say, oh no, we don't test for that. Oh, the whole world has that. Oh, don't worry about it. You okay. From somebody who just really recently got tested this year. I did not tell them that I had herpes. They literally called me. They called me and said, "Oh, Miss Spivey, everything's good, but you have herpes. It's no big deal." I asked them, "Do I have to tell my partner?" They said, "No, it's not necessary. Everybody has it." So with that being said, devil's advocate here, the chances are R. Kelly could have received his diagnosis and his doctor said it wasn't necessary to tell. Long as he was on his medication, he was fine. I'm blinking because I need y'all to hear me. Let me tell you, everybody do not have herpes. Let's kill that today. Everybody do not get cold sores. Everybody do not get fever blisters. Everybody do not have herpes. Period. Do stop. I'm gonna say this. Stop connecting chicken pox to herpes. They're under the herpes family, but it's not herpes simplex. Two different things. It's so many different, like shingles, all of that stuff. It's all different things. Do not attach. Everybody do not have herpes. Yeah, 90% of people have it, and I'm gonna say 80% have no clue they do, and never will. Herpes is not always painful. It don't always look like you think it's going to look. It could be a simple cut. It can look like a hair bump. You may think you're sick. You may think you're getting a sore throat. You may think you're having a little headache. You may think since you've been going to the job, working out, that your body just aching. Or you think your legs just hurt. So this is the reason, based off this situation, based off R. Kelly's situation right now, y'all. This is a misdemeanor. They're doing personal injury claims, like personal injury lawsuits on him, which they want pain and suffering and probably medical. And since he committed a sexual crime, the chances this may stand. The chances this probably will stand. Chances are. If these girls got really good lawyers. If them girls got really good lawyers, it'll stand. Because this was a sexual crime. So I want to get into this. I want you guys to understand that herpes, since it's not included in the panel, when people are trying to sue people like this, it can be difficult. And that's what I want y'all to hear today. This is a difficult situation. Because at the end of the day, based off the information you know or what he did not know, could be the reason why these young ladies have herpes. For the lack of knowledge that he has, could be the reason why these girls got passed on to these young ladies. And this is the reason why I stand on this platform and I talk as loud as I do with all the energy I have, is because stuff like this is happening to people. This is happening every day. It's 20 cases or more in your clinic every single day. You know how many clinics and OBGYNs and all this stuff that's around the world, y'all? Well, just in the United States. I'm just saying. This is a prime case of why herpes needs to be talked about. It's so many times that herpes continue to come up in sexual crimes, rape, molestation, all of these things. Okay? Don't come this way. Don't come this way. Don't come this way. That come into sexual crimes. Also would come with cheating. Somebody just said something about Usher. Nobody knows for sure Usher has herpes. He did not confirm it. With R. Kelly, it's confirmed. Usher, it was never confirmed. Because that young lady ended up coming back and saying that she didn't have it. She thought she had herpes, but she got tested and she did not have it. Okay? I did a video on that on my YouTube. What are y'all doing? Hayden, watch your attitude. Get the boxes and go. I'm a mama first, y'all. So, that's the situation, y'all. This situation, I want to keep it short. I want to keep it sweet. Based off this is what's happening. Also, in every state is different. So did she get paid? No or yes? No, that young lady with Usher never got paid because she never had the virus. And he never confirmed if he did or not. Which he didn't have to because it's against his HIPAA to share. He don't have to share his HIPAA with y'all. But since the fact that R. Kelly is in the middle of a sexual crime and his stuff is public and we know that he had sex with these minors, then all this information is getting put out. Because these girls want to make sure he stay under the jail. Okay? So these young ladies, right now, he is up for 9 counts of misdemeanors, or I don't even know how to say that. Y'all know it in law. He got 9 counts. And it's a misdemeanor. He is up for something. 9 counts, y'all. On top of having sex with minors. Woo-wee. I'm telling y'all better check these false IDs. Take it to the DMV to make sure it's real. So that's that. I just want to come on and share that with you guys, especially for somebody who's on this side of the fence, to give you some real information outside of some people who's going to share it. And it's more of a gossip thing. This is not a gossip thing. This is more showing y'all what's really happening. Because a lot of y'all going to speak on it. You know, I love y'all. We're going to speak on it on different situations. People are going to argue back and forth. But I want to come from an educational piece, explaining to you guys exactly what's going on and what's happening. So now when y'all go somewhere and y'all talking about it, then y'all kind of understand it from the young lady's standpoint. And also you can understand it from R. Kelly's lawyer. I'm going to play this out. Listen, I can't wait to see what they're going to say. Because I'm going to come back when I want to see what they're going to say. And I'm going to come back and kind of give my feedback on what happened and why it happened. Okay? But I'm telling y'all, I'm being real. If he got really good lawyers, he going to probably get off on this. But the fact that he did a sexual crime, that's going to be the only thing that really, really hard stick. The fact that he's committed a sexual crime with these young ladies. It ain't going to be just the fact that he has herpes that's going to stick. It's going to be the fact that he did a sexual crime that's going to stick it. Which, I'm not going to lie, he wrong. I mean, it is what it is. He's wrong. And this is happening with many individuals. This can happen to people all the time when people try to sue an individual believing that person knew or that person did know. But the question is, what type of knowledge did they have about disclosing disclosing their status? Most people are super scared to disclose their status. They don't want to be judged. They think of the stigma, things like that. That's why I come on here letting y'all know, like, listen, tell the truth. Don't do it. Okay, I was taught that. Okay, I was taught the same thing. You ain't got to tell no big deal. I'm telling you, it's not the right thing to do. It's not the right thing to do. Listen, it's not the right thing to do. I know it's hard. It's not the right thing to do. I ain't gonna really speak on what these females, they were minors. They were children. Children do stuff. Listen, speaking on young ladies, most young ladies have had, especially if you got a body, have had older dudes talk to you. It was R. Kelly, y'all. Not trying to be mean or anything, but I think with some of the situation, with some of the parents knowing that, I truly believe the parents should be held responsible as well. That's just me. I can't hold children responsible. They're minors. Okay? They don't know any better. Listen. Oh my God, a celebrity is coming to talk to me. He wants to spend time with me. Starstruck, y'all. Starstruck. We're not in that time anymore. Some people may, but it's not as bad as it used to be back then. Yes, older new like to take advantage of younger girls all the time. And I even talk about women. It's older women who like to take advantage of younger men all the time. It's both sides of the fence. We just don't talk about it with the women, but women do it too. I agree the parents should be held. Absolutely, I agree. The parents should be held responsible. And I feel like at the end of the day, if I was a lawyer, I would be coming from the parents too. Yeah, agreed. Not all minors, but I'm saying I'm speaking from a place of I agree. I'm with you with that. All wasn't minors, but most of those girls were minors when they had sex with R. Kelly. Most of them are not minors anymore, but most of the young ladies were minors. They were under 18 or 18. They weren't 21, y'all. They say 18 is legal, I guess, but I don't think 18 is legal. What y'all can think? But most of them was like teens. They were teenagers, okay? But most of those girls are grown now. Most of those girls are grown. So that's my take, guys. I'm done. R. Kelly need to pay the price for what he did. Listen, I ain't lying. I'm with you. He did that. But at the end of the day, he gonna have to pay the price, because at the end of the day, he could have sex with anybody, but he been having sex with minors. But we know how the industry get down, y'all. It depends on the state he had sex with them and the age. Now, that's true. That's another thing, too. Because at the end of the day, some states still allow you to marry girls at 13. So that's something else we also got to consider. New York is a little different, okay? This is in New York, okay? So also when we're looking at this case, y'all, we need to consider the state of the case. Because remember, a lot in the Midwest, literally, girls get married young. In the South, the laws haven't changed. Remember, every law have not been pulled up. All right? Every law haven't been pulled up. I think in New York, a lot of this stuff stands. Okay? So that's another thing we got to consider. So I'm happy you brought that up. Okay? That was a good thing. Remember, every state is different. Even with, if you felt like that person knew you did not have it prior, things of that nature, and you want to do a personal injury claim, you got to understand that it depends on the state. And it also depends if the lawyer feel like they can fight the case. Right now, R. Kelly's lawyer feel like they can fight this case. Okay, but what they not looking at, like I'm looking at, is the fact that he did a sexual crime. Now, if they came and said R. Kelly gave him herpes, okay, and it was consensual and these girls was over age, y'all, no lie, it wouldn't stand. But the fact that he was having sex with minors, it was a sexual crime, he in trouble. He is in trouble, okay? He is in trouble. He is in trouble. That's the thing. So just imagine if you are talking to somebody, this is what you want to do. It's hard to stand because at the end of the day, it's not including the testing. It's not, y'all. You will never know when you ever had contract herpes. If you was a virgin, you had to be a virgin. I mean, and when I mean virgin, no sex. Oral sex is sex, y'all. I love y'all, but we need to get out of that mindset that oral sex is not sex, okay? That's sex. I mean, all right, if they put their mouth on you, it's still sex, all right? You can still contract that way. So if you didn't do anything at all, that's the only way for you to really, really know where it came from. Because real talk, if you go back, even if you had two partners, those partners will come back and tell you, I ain't give it to you. If you don't see their test results, you'll never know. I have ladies say, I ain't had that many partners, and everybody saying they ain't got it. Baby, somebody lying to you. It's just that simple. Somebody is lying to you. Or, let me not say sex. You remember you can get herpes from kissing. So if you ain't never kissing somebody, it didn't spark my mind. I want us to stop attaching herpes to just sex. Let's attach herpes to skin-to-skin contact. Let's do that. We got to do better with that, y'all. Me too. Okay? You don't get herpes from just sex. You get herpes from skin-to-skin contact.
Well, thank you, Coach Belize, for that. Always. Thank you. And thank you, everyone, for coming. So again, about the herpes situation. Herpes. Lord of mercy. Yes, everyone, please hit the like button. And if you have any comments, please leave your comments below in the section of the comment portion to this video. If you're not subscribed, please subscribe to my channel. Hit the like button on the way out. Thank you very much, guys. It is almost 2 a.m. I am ready to hit the sack. I don't know about y'all. Thank you for everyone for coming and chilling out with me. Yeah, so basically the government wants the judge to deny the claims that the defense team put in their motion to dismiss and to amend the jury charges. Okay. So, yeah, and I put in the link. I put the link to I shouldn't say doctor, to Coach Belize, to her channel. It's there in the chat, guys, if you would like to follow her and continue to watch the video on your own. Please do so. Please. She gives a lot of knowledge, personal experience, as she said, as well as research that she has done. And she's lived with herpes for quite a while. So take her advice. All right. All right, guys. I love you. Peace.